All right, good afternoon, everyone. Thanks for joining us for our third webinar, our third Washington Passport Network webinar. My name is Donna. I'm with the College Success Foundation and the Washington Passport Network. I'm really excited this afternoon for our webinar. We have a guest presenter, guest speaker, Laurel Simonsen, who's the managing attorney at Center for Children and Youth Justice. And she's here today to present about landlord and tenant rights in Washington State, and then how you as a supportive adult can help a young person as they transition into independent living. Laurel, I'll pass it on to you.
Awesome. Thank you so much, Donna. And thanks to everyone who's joining us this afternoon. Like Donna mentioned, my name is Laurel Simonsen. I'm the managing attorney for a program called Lawyers Fostering Independence at the Center for Children and Youth Justice. So what I'd like to do today is just start off by giving a little overview about what my program does and how we've been connected to College Success Foundation in the past, and what we can do to support youth and young adults in Washington in terms of legal needs. And then we'll dive into sort of an overview of the major issues that we see arise from landlord-tenant interactions in Washington, and talk through some of the major potential problems and pitfalls that you can help young people navigate. And then hopefully we'll have enough time to go through a scenario at the end where I'll give everyone sort of a few minutes to read through a hypothetical, and then we'll talk through what that young person can do and what their options are and when to get connected to legal assistance. So,
and Laurel, sorry, before we get started, wanted to mention that this webinar is being recorded, and we will be uploading it onto our WPN YouTube channel as well. And so if you need to refer back to any of the talking points after, this will be live on our, uploaded onto our YouTube website or channel.
Awesome. Thank you. Okay. So just to start off with a brief overview of LFI, we provide civil legal assistance to young people between the ages of 17 and 25 who have either lived experience in out-of-home care, whether that's formal foster care or kinship care arrangement or group homes, and to young people who have either experienced homelessness or are at risk of experiencing homelessness. We currently provide services in King, Snohomish, and Pierce counties. But we do try to be as flexible as possible with assisting young people who may live outside of our service areas, either with providing limited consultation and advice or getting them connected to services in their area. So if you're working with someone who doesn't live in one of our service areas, please don't hesitate to reach out to us if you have questions or want to get them connected to assistance. The way that our program works is that we are staffed by 2 attorneys, myself and one other person, and we do a lot of legal outreach. We staff 7 monthly drop-in legal clinics throughout our service areas, where we meet with young people and talk about what's going on and figure out what sort of assistance they're needing. And then we actually work to partner with pro bono attorneys in the community, so folks who either have their own practices or work at major law firms or other legal organizations who take our cases pro bono. So that's actually how we staff the majority of our cases. We also do a lot of legal outreach and education work. So we do regularly scheduled Know Your Rights presentations where we'll go into schools or job training programs, youth shelters, basically where our potential clients are already accessing services, and give them an opportunity to be informed about what their legal rights and responsibilities are on a range of issues, whether that's landlord-tenant law like we're going to talk about today, or interacting with law enforcement, employment rights, rights around driver's licenses and insurance requirements, those sorts of things. And then we also do provider trainings like the one today, where we connect with service providers and other professionals who are interfacing with young people in their own professional capacities, so that we can help empower you as adults to help young people navigate these sorts of issues, and not in a you have to provide legal advice sort of way. In fact, that's precisely what we don't want you to feel like you have to do, but to help young people potentially recognize things that could turn into legal issues and what their rights and responsibilities are to try and navigate through those, and when and how to get connected with legal assistance if something becomes truly urgent in that way. So like Donna mentioned, today's goals are, initially I just want to provide you with a general overview of Washington landlord-tenant law. Specifically, and I just want to acknowledge, like, this is a really big topic, and it's something that we could spend days and days and days and days talking about and still only have an overview. So in 1 hour, we're definitely just going to be scratching the surface, but the objective that I set out with was to help identify some of the major issues, again, that we see with young people who access our services. These tend to be some of the more common potential pitfalls for young people who are entering into residential leases or dealing with issues with roommates or things like that. And then the second objective is to help empower you as adults and systems professionals and service providers to help young people identify these issues, maybe even before they occur, and to provide guidance on when and how to access legal assistance if the young person needs it. So before we dive into sort of the substantive aspect of the webinar, I did just want to say that there are going to be some sort of natural breaking points in the presentation to ask questions. So Donna's going to be fielding the Q&A and chat tabs as we go. So if something urgent comes up, please feel free to put your questions in the chat bar or question and answer fields, and Donna can help flag those for me as we go. But I have divided the substantive part of this up into 3 sections about pitfalls that arrive when you're getting into housing, what can happen when you're currently living in housing, and then also when you're leaving housing. So after each of those sections, I will take a quick minute to pause and we can try to get through all the questions that might come up. But feel free to send them as they come up for you. You don't have to hold them until those stopping points. So, Washington landlord-tenant law, at least residential landlord-tenant law, is governed by a specific statute called the Residential Landlord-Tenant Act of 1973. There have been lots of changes that have happened to it since 1973, but this is basically the major piece of Washington law that governs the rights and responsibilities of both landlords and tenants in residential lease agreements. So this is going to cover any sort of agreement between a person and either a private landlord or a leasing agency, whether that's a standalone house or a small apartment building or a major complex with that's owned by a company that owns hundreds and hundreds of complexes, maybe all over the country. This specific piece of law is going to be what holds all of the rules and regulations that folks have to follow. This does not include commercial leases, and it doesn't include lease agreements that may come through like university housing. So if a young person's living in a dorm while attending college, the Landlord-Tenant Act is not going to be what governs their rights and responsibilities in that living situation. And there are other protections for folks who are living in federally subsidized housing. So we are not going to talk about that today, but if you're working with a young person who has subsidized housing and is dealing with any sort of issue that comes up, it may even be some of the same issues that we touched on today. They have different protections in place that are specific to the type of subsidy that they may be receiving. So again, this is just sort of an overview of how I've broken up today's presentation. So youth can, really anybody, but young people in particular can experience different types of legal issues at different points in their rental experience. That can be at the outset when they're trying to get into housing, It can be during the time of their tenancy, really at any point from basically move in to move out. There are all sorts of different types of issues that can arise. And then I would say probably the most of the time that when we see issues arise, it's at the point where the young person is trying to leave or has left housing, and that's when those issues kind of come to the forefront. Even if it's something that might have arisen earlier, it doesn't really come to a head until the young person's leaving that specific residence. So again, we'll sort of stop at the end of each of those sections to answer any questions that have come up, and hopefully this will be helpful for everyone. Okay, so issues that can present barriers into getting housing. That can be pretty diverse. It can be something from their past rental history. I don't know if anyone's worked with young people who have past evictions on their record, but having a history of eviction can be a major barrier to finding housing in Washington. Unfortunately, Washington law is very favorable for landlords in the area of evictions. There is very little that we can do to mitigate the effects of an eviction going forward. So one of our philosophies on providing housing advice and assistance to young people is that if we will do everything we can to avoid having an eviction filed, we take any sort of notice of eviction very seriously because it can create such a significant barrier going forward. It's certainly not impossible to find housing with an eviction on your record, but it does present a major obstacle for a lot of folks. Similarly, having negative credit history, and whether that is from a past debt that's owed to a landlord or outstanding credit card debt, school loans, anything that might be in collections. A lot of landlords require a credit check or a minimum credit score in order to rent their units. And so negative credit history can be a problem for sure. And that includes any sort of negative credit history that might be the result of identity theft. So even if the young person did not engage in any sort of or didn't take out any sort of loans or credit cards or whatnot, if there's an account that has been linked to the young person fraudulently, that can still impact their housing. And we would have to navigate getting their identity resecured and addressing any outstanding fraud before that would cease to be a barrier for young folks trying to find housing. Similarly, in Washington, landlords are allowed to deny residence to folks who have criminal records, both juvenile and adult records. So we do have a lot of options in terms of dealing with juvenile criminal records here in Washington. We have fewer options for mitigating the effects of adult records, but that is starting to change. And those are certainly things that legal assistance can help with. We can help talk to a young person about what their options are to either seal or expunge or vacate any past records, and work to establish a narrative that they can use with prospective landlords to talk about what is on their record, how to talk about it, how not to talk about it, when to disclose it, those sorts of things. So again, those are things that having some legal assistance, even if it's just a limited consultation, can be really useful to break down those barriers to even getting into housing in the first place. So some of the things that we see a lot of sort of down the pipeline that really should be at the forefront of young folks' minds when they're looking into getting an apartment or renting a house either on their own or with roommates are sort of these following issues. Budget is a big one. Understanding what the true cost of getting into an apartment is, not just what the monthly rental payment is, but what sort of deposits are required. Do they have to pay first and last? Are utilities included in the rent? And if not, who's responsible for paying the utilities and to whom? Do they owe them to the landlord directly, or are they supposed to set up the accounts with the utility companies? Understanding the types of deposits and fees that are owed up front, not only just the dollar amount, but also, is this a refundable deposit or is it a non-refundable fee? What's it used for? Are there pet fees or screening fees, or are there ongoing rents that are going to be owed for pets? Really understanding the true cost of what it is going to take to move in and then sustain their tenancy there is going to be really critical to making sure that it's successful going forward. We oftentimes will see young people who really stretch their financial means to get into housing, and then even within the first month or two are not able to make their initial rent payments because they've sort of exhausted that safety net just to get in the door. So really having a clear understanding of what the costs are going to be, what their budget is, and being able and willing to stick with the budget that works for them. One thing that we oftentimes encourage young people to do from a budgetary perspective is to consider having roommates instead of living on your own. Washington is ever increasingly becoming a very expensive place to live, and not just in, along the I-5 corridor. It is very hard for a lot of folks to find a place to live on their own. And so roommates are oftentimes the solution to being able to get an apartment or get a house. However, roommates also open up a whole slew of other liabilities that young people may not be aware of. So in Washington, we have what's called joint and several liability when it comes to roommates, which means that every individual on a lease agreement is going to be wholly responsible for the terms of the lease agreement on their own. And so if, let's say I get an apartment with my friend Joe, and Joe decides to skip out 6 months into our 12-month lease agreement, I am going to be responsible for paying all of the rent, including Joe's portion, for the remainder of the lease agreement, unless I can find somebody to take his place, or and then my option is that I can go take Joe to small claims court or file a lawsuit to recoup any money that he would have owed me under that lease agreement. But as far as the landlord is concerned, I'm responsible for all of it, or Joe is responsible for all of it. That can get young people into a lot of trouble if they end up rooming with someone who they either don't know is trustworthy, or if they know somebody is in a hard place and may not be able to financially meet their end of the bargain. That can create some substantial liability for them going forward. That could lead to an eviction or outstanding debts that go into collections, which again sort of cycle back into these barriers that can make finding housing in the future even more challenging. So understanding that is, I think, really important, and encouraging young people who are looking to find roommates or looking to move in with a friend to be really careful in considering who they sign a lease agreement with, because it is a binding legal document and that they are taking on the liability for that other person's conduct as well. So this last one is kind of a big blanket category, but knowing the terms of your lease agreement. Again, this is going to be understanding how much rent is owed, when is it owed, how do I pay it? Do I pay it to the landlord? Is there an online portal that I'm supposed to use? Do I send it to a specific address? Is there a Dropbox? But knowing exactly when and how rent is paid, how much. Again, utilities, whether those go directly to the landlord, if the landlord covers utilities, if not, how do I set up the accounts with the utility companies and make sure that those get paid on time? Am I allowed to have pets? If so, how many? How do I get them approved? Are there any fees or pet rent that's due? Another one that I've seen young people get into trouble with is having guests at the apartment. A lot of landlords will have, some part of their lease agreement that will place limitations on how often they can have guests in a unit, whether that's, one person can only stay for, 2 nights in a 1-month rental period, or, no guests over for more than 5 days total or whatnot, and understanding what that limitation might be. I think it's something that young people don't necessarily anticipate being part of their rent agreement. And so really truly understanding all the ins and outs of what exactly they're signing on to. And then going into this really the nitty gritty of, or, you know, the basics of what the rent agreement is. How long is it for? Is it a term lease where it's for a set period of time? Usually in Washington, the most common length of time that we'll see is a 12-month lease agreement. But they can be for any period of time, longer or shorter. So it could be as short as like a 3-month, 6, 9, whatever. It really is up to the landlord's preference as to how long they want to set a term lease for. Or is it a month-to-month agreement? And understanding the difference between those is really important because there are different rights and responsibilities that both the landlord and the tenant have depending on what kind of agreement it is. For term lease agreements, generally speaking, the landlord can't change the terms of the lease for that entire length of time. So if I sign a lease agreement for 12 months and my rent is $1,000 a month and I'm allowed to have a dog and I'm not responsible for utilities, then for that whole 12 months, the landlord can't change that. But if I have a month-to-month agreement, the landlord can change the terms of my lease agreement as long as they provide me with proper notice before the next rental period. So they can increase my rent. They can decide that I'm not allowed to have my dog anymore. They can decide that I'm responsible for paying all the utilities. And they just have to give me enough notice, which depending on the type of change is usually between 20 and 60 days. And I can decide whether or not I want to agree to that and stay or leave, but it does provide a lot less security on a long-term basis because the landlord has a lot more power to change the terms of the residency agreement. So really, again, last bullet point here, know what you're getting into. Understand what you're signing. If you have questions, it's totally okay to ask the landlord, to call me, to talk to another attorney, to talk to a case manager or counselor or service provider who can help navigate what exactly the language of the lease is saying. And if it seems weird or shady or doesn't seem straightforward, like, let's get it cleared up before you sign on to it, because we want to make sure that no one's signing on to something that they can't follow up with. So the last thing I want to talk about before we move on to living in housing is there is a legal requirement when anyone moves into a new rental property that the landlord has to give them a move-in checklist. And basically what it usually looks like is a blank piece of paper that's going to list off all the living spaces in that particular unit. So if it's a 1-bedroom apartment, it will be the bedroom, bathroom, kitchen, living area. If it's a big house, it'll be all the different bedrooms and living spaces and whatnot. And the landlord and the tenant have a right to go through the property and list exactly list the exact condition of every living space in the unit at the time that the tenant takes possession. So this is something that oftentimes just feels like just something you got to do. You're signing all your lease paperwork, you're signing any sort of lease addendums, you're given this checklist that says, like, here's the condition, like, we replaced all the carpet and fresh paint and everything's new, and the landlord will oftentimes just go check, like everything's new, and give it to the tenant to sign. And that's oftentimes what happens is the tenant will sign it just thinking like, okay, I just have to sign this and then I'm done. But the tenant actually has a legal right to go through the unit and actually verify that the condition of the apartment is what the landlord is claiming that it is on that checklist, and to document any specific damages or wear and tear or things that need to be repaired at the outset of the lease agreement. So this is important for a couple of reasons. One, it gives the tenant an opportunity to ask for things to be fixed that need to be fixed before they move in. Like, make sure that all the doors and windows close and lock appropriately. Make sure that the faucets turn on, the toilets flush, that all the light fixtures work, those sorts of things. More importantly is that this is going to be basically worth its weight in gold when the tenant moves out at the end of their lease, because that's going to be the document that the landlord will compare the condition of the apartment at move out to what it was when the tenant moved in. So making sure that there's an accurate description of any sort of damages, wear and tear, anything that's not new or in pristine condition, you want to have documented on that checklist. Otherwise, the tenant can be held financially responsible for making any of those repairs when they move out, even if that was the condition at move-in. I cannot stress the importance of this move-in checklist enough. I would say 95% of our legal issues that we see at move-out could be substantially mitigated by a well-documented move-in checklist if we're dealing with landlords alleging that the tenants are responsible for paying for repairs that were the case already when the young person moved in. So in addition to making sure that the checklist is done completely and thoroughly, like don't tell anybody you're talking to, make sure that they do not sign that checklist until it's accurate, and they don't have to sign it if it's not right, and that's okay. They have a legal right to make sure that it's accurate. Is not only make sure it's accurate, but also keep a copy of it. And that goes for any other of the leasing documents. So a copy of your lease, any addendums, the move-in checklist, any communication with the landlord, keep a record of it, because those are going to be really, really important if and when any sort of issues arise down the road. We'll want to be able to go back and look at the checklist. Quick note, also totally okay to take pictures and keep a copy of them. Take them while they're doing the checklist and put them in make sure that they're date stamped and keep them in a file that's with the move-in checklist, and that will be really, really valuable in the event that the landlord alleges any damages or necessary repairs at the end when the young person moves out. Okay, so this is a good place to stop for questions.
Yeah, we do have one here, Laurel. It's from Sarah at Treehouse. Is there a timeline requirement for how long the tenant has to review the move-in checklist?
I think that the landlord has to provide it at the point when the tenant moves in. I do believe that there is a time requirement. I want to say 2 weeks. I don't know that off the top of my head, but I can certainly look that up and get back to everybody. I can send the information to Donna or figure out how to disseminate that. But yes, there isn't like a open window. It has to be done within a pretty short period of time of when the tenant moves in, just to, again, get that point in time capture of the condition of the unit. We good to move forward?
One more question from
Yep.
Dawn. If the tenant did not realize they were signing the checklist when they moved in, is there any way they can do it later?
There is. It's a little more complicated. But it's really not so much that they get a chance to redo the checklist, but if the tenant notices that there are necessary repairs, or if there's damages that they didn't notice at move-in, it is important to document that when it's noticed and provide that documentation to the landlord. General best practice is going to be to say, I wanted to let you know that I discovered that there's this thing that needs to be repaired, or there's something that's damaged that I did not cause. I wanted to let you know about it, and provide written notification, timestamp it, take pictures, provide that to the landlord, keep a copy for yourself. Things break when people live in their units too, right? Like landlords, and we'll talk about this in our next section, but landlords have an obligation to do repairs if and when things break, if it's not caused by the tenant. Sometimes even if it is caused by the tenant, but we'll get into that.
A couple more things, Laurel. Sarah shared that in their experience, it's been 7 days for the turnaround for tenants to.
Yeah, that sounds right. Again, I don't know the exact timeline off the top of my head, but yeah, 7 days, that seems reasonable to me.
Okay.
So.
And then another question, can landlords in Washington state use secret algorithms to qualify tenants?
I'm sorry, can you repeat that?
Yeah, can landlords in Washington state use secret algorithms to qualify tenants?
You know, I don't know the answer to that question. That's not something that I've had any experience with. I know that there are lots of folks that are working on breaking down sort of the black box of decision making that happens oftentimes with folks getting qualified for housing. In Seattle, for example, there is now a new law that the first qualified applicant is supposed to get it's supposed to get the unit. It's really a first come, first served basis, and it prevents landlords from sort of screening for their preferred tenant as opposed to the first person that meets the requirements. So I'm personally not aware of the use of secret algorithms. I don't know what sort of like legal limitations there are on using any algorithms, just because it's not something that I'm familiar with.
Mm-hmm.
Okay, so I think if we're okay, I'm going to go ahead and move on to our next section.
Oh, sorry, Lil, we have one more that just came in. Is the law that the landlord has to accept the first qualified applicant only in Seattle, or does that apply statewide?
I believe it's just in Seattle.
Okay.
And that's the other thing, is that today's overview is really based on Washington state law. There are certain protections that are more helpful for tenants in specific jurisdictions, whether that's by county or municipality. So, for example, Seattle actually has, I think, a much more tenant-friendly, they have a more tenant-friendly municipal code than Washington state does overall. But the Washington state protections are basically setting the bare minimum. So there may be more protections than this for tenants, not less. Okay, so I have a ton of notes on this one, so I'm just going to kind of fly through them really fast. And then, again, we'll pause for questions at the end. So some of the things that I think really at the end of the day, the things that come up when a tenant is living in housing, like the issues that can present major issues, are going to come from not understanding what the tenant's rights and responsibilities are versus the landlord's rights and responsibilities. So I'm just going to do a quick overview of what tenants can and can't do, and what the landlords can and can't do as well. So when a tenant signs a lease agreement, the general assumption is that tenant has the right to live and enjoy the space with privacy and use the property as their own for most intents and purposes. The landlords are not allowed to generally interfere with the tenant's use of the space. That doesn't mean that tenants can use the property for anything that they want. There are still limits on that, but landlords are not allowed to just hop in or interfere or check in on tenants without providing proper notice or without having a just reason to do so. So the tenant's major responsibilities during the time that they're living in their dwelling unit is that they have to pay rent and utilities as agreed upon, on time, every time. They have to follow all city, county, and state regulations. They have to keep their unit clean and sanitary, including disposing of garbage properly, both in and outside the unit. So that does mean that just because, they're living there and paying their rent on time, folks still have to make sure that they take their trash out, clean up after their pets, both in and outside their units. They have to pay for pest control or pest removal if the infestation is caused by the tenant. So this is one that we have seen in the past that can be a little bit of a gray area, particularly with things like bed bugs, where it may not be clear whether like the landlord may dispute that there weren't bed bugs in the unit, and now there are, and so they're going to claim that it's the tenant's responsibility. So tenants, want to make sure to be really clear about what the condition of their belongings are when they come in, and be really careful about what they bring into the unit. Similarly, things like ants, like sugar ants or cockroaches, or things that, or even mice or rats that can be attracted to waste or food or whatnot that's left in the unit. Those can be determined to be the tenant's responsibility to get rid of. If it's something where the landlord isn't providing any sort of external pest control, and there's a place where rats are getting into the attic or crawl spaces or whatnot, those are definitely going to be the landlord's responsibility to tend to. Tenants have to properly use plumbing, heating, and electrical systems, so not overwhelming those systems, not trying to flush non-flushable things down the toilet, whatnot. They have to notify the landlord of necessary repairs in a timely fashion. And they have to restore the property to the same condition at move out minus general wear and tear. Tenants are not permitted to engage in any illegal activity on the premises, including drug use or gang involvement. Really, any sort of illegal activity can be grounds for immediate eviction with very, very little notice. So that's just, again, have to follow the law, even in their apartments. They're not allowed to allow damage to the property, either by themselves or their guests. Again, cannot allow accumulation of garbage in or around their unit. They also can't substantially interfere with other tenants' use of their property. This we oftentimes will see. We see this most frequently in the terms of noise complaints. So they have to follow the general rules of the lease, abide by quiet hours if there are any. But even within those, non-quiet hours, if music is played too loud, or there's, thumping or yelling or lots of people and loud parties and whatnot, like that can be a violation of the tenant's responsibilities. And again, their tenants are responsible for the conduct of their guests, so they can't allow their guests to engage in any of those prohibited activities either. Unless there's an emergency or the landlord has determined that the tenant has abandoned the property, the landlord must give notice to enter the unit for any reason, whether that's to just do an assessment of the condition of the property or to do repairs. Generally, the amount of notice that is required is 2 days. However, if the landlord is showing the dwelling to either a prospective buyer or a prospective tenant, they only have to provide 1 day notice. The notice does have to be in writing, and the tenant does have a right to ask to reschedule, but the landlord does not have to accommodate that. And tenants are not allowed to prohibit entry if the landlord has provided proper notice. I would say in most cases, landlords will try to accommodate tenants' requests if things are just like really a bad time, but unfortunately the tenant doesn't have a lot of rights in terms of saying like, no, you can't come on this day, you have to come a different time. So that's kind of an overview of the tenant's responsibilities. Landlord's responsibilities are basically summed up as follows. They have to maintain the unit so it doesn't violate any state or local laws in a way that endangers health or safety. So they basically have to keep the unit habitable. They have to keep any shared or common areas reasonably clean and safe. So if there's any sort of courtyards or shared outdoor space or hallways, elevators, stairwells, those sorts of things. They have to fix structural damage to the units, including roof, chimneys, floors, any other structures in living spaces. They have to maintain a reasonable pest control program, except when the tenant causes the issue. Provide good locks for the unit and give keys to the good locks. That also includes changing locks if a tenant gets a court order that bars entry for a former co-tenant. So the most common time we see this is if someone gets a domestic violence protection order against a spouse or partner who had been sharing the space, sharing the residence with them, but then gets that protection order and the spouse is no longer, or the partner is no longer allowed in the unit, the landlord has an obligation to change the locks and provide the new keys to the tenant who's continuing to live in the space. They have to provide fixtures and appliances for heat, electricity, and hot and cold water. They have to provide working smoke detectors, which just means that they have to work when the tenant moves in. Tenants are responsible for maintaining batteries and smoke detectors. If the tenant pays rent in cash, the landlord must give them a receipt, whether or not the tenant asks for it. And they are responsible for providing a receipt upon request for any other payment method, whether that's check, money order, online portal, whatever it is. If the tenant asks for a receipt, they have to get one. And then landlords have to make repairs when something breaks. Except for, there are some exceptions for things like wear and tear. So like if the light bulb burns out, landlord doesn't have to do that. If the handle falls off a sink, the landlord does have to fix that. Repairs do need to be made in a timely fashion, and timely is dependent on what type of repair it is. Generally speaking, if there is an issue with hot or cold water, electricity, or heat, or any other life-threatening problem, the landlord has 24 hours to start repairs. Any issues with fridge, stove, oven, other major plumbing fixture, the landlord has 72 hours to start repairs. And then all other repairs, the landlord has 10 days to start repairs. So the most important thing here is that the tenant has the responsibility to provide the notice to the landlord of the necessary repair. So the landlord isn't going to be responsible for, fixing the heater within 24 hours or getting that repair started within 24 hours if the tenant doesn't timely notify them. Notice of repairs do have to be provided in writing. Generally speaking, the best type of writing is a letter that you would send certified mail, but that's also just not the world we live in anymore. So generally speaking, writing can be an email. It can also be a text message if there's a history of communication between the landlord and tenant using text message. If the tenant's never texted the landlord before, might be harder to construe that as proper notice. But email, web portal, if they live in a managed unit where there's oftentimes like 24-hour service on call, you want to follow that recommendation, follow those policies for sure, but make sure that any notice is done in writing in a way that is most effective or most likely to be effective in communicating that to the landlord right away. And then there isn't a set time limit on how long repairs have to be completed by. The statute says that they have to be done in a reasonable time frame. Reasonable is going to look different for a broken furnace in winter than it's going to be for a broken light fixture in a dining room or something. So the courts have sort of interpreted reasonable differently depending on the type of the repair and the time of year that the repair needs to take place, depending on how essential that repair is. So if no repairs are started in those specified timeframes, again, so that 24, 72 hour or 10-day window, and notice was provided properly, tenants have a range of options that they can exercise. They can either choose to pay someone to do the repair themselves. They can do the repair themselves. But in both of those cases, there are limits as to how much they are allowed to spend on the repairs. They also have to let the landlord know that they intend to do that. They have to give a good faith estimate of the cost ahead of time. And they also may be liable for any faulty repairs that are done if the landlord has to pay to get that fixed. They can choose to move out, or they can go to court or arbitration to try to compel the landlord to do the repairs. Generally speaking, if there's an issue around a repair not being started timely, I would strongly recommend that you refer someone to our program or another legal service provider to get some advice on their options to make sure that whatever option they exercise, they're doing so properly and are aware of the potential risks or pitfalls that might happen if they do it incorrectly. At no point can a tenant withhold rent because a repair has not been done. That is a very, very fast way to start an eviction proceeding. Rent has to be paid on time, every time, even if the landlord is not following their responsibilities around repairs or privacy or habitability or whatnot. If those are issues, we want to address those issues, but that does not relieve the tenant of their responsibility to pay rent. Let's see. Sorry, just making sure I got all of this. So tenants do have a responsibility, again, to follow the terms of their rental agreement. They can't have unauthorized guests. They can't get a dog or a cat if it says that they're not allowed to have pets. They have to pay rent on time every time. If the landlord has any reason to believe that the tenant is not following the terms of the rental agreement, whether that's unpaid rent or non-compliance with some other term of the agreement, they can provide notice of either the requirement to pay or comply with the lease or to vacate the premises. And the amount of notice required depends on what the alleged offense is. Up until July of this year, landlords could do what was called a 3-day pay or vacate. So if the tenant was even 1 day late on rent, they could post a notice on the door that says you have 3 days to pay the full amount of rent or you can vacate the premises. Starting July of this year, they actually extended that notice requirement to 14 days, which is a huge win for tenants because, especially for folks who are, living paycheck to paycheck or really struggling to make ends meet, 3 days to come up with money that you don't have is not enough time. So 14 days provides a much more manageable window to at least either come up with the money or come up with a plan B and figure out how you want to try and deal with that situation. For other non-compliance, so noise complaints or issues around, waste management or other just general terms of the lease agreement, the normal notice period is 10 days. And if the landlord is alleging that there's any illegal activity taking place in the unit, which again, drug activity, gang activity, domestic violence, any other sort of illegal conduct, they only have to provide 3 days notice before they can start an eviction proceeding. Like I mentioned at the outset, we treat any potential evictions we treat them very seriously because they can create major barriers. So we recommend that if you are working with a young person who receives a notice, that they get in contact with legal services immediately to try and mitigate the potential impact of that notice and get it remedied. Okay, that's the end of that section. Any questions? I know we're kind of running short on time, which I wasn't anticipating.
Yeah, we have about 10 minutes scheduled left. But
I'm happy to just keep powering through if there aren't any pressing questions.
no, I don't see any coming through.
Okay, awesome. So this is where we will see the most of these issues come up is when a young person is leaving. Again, we sort of talked about eviction just now. I don't really have a lot more to add to that other than in King, Snohomish, and Pierce counties, there is what's called the Housing Justice Project. If you are working with a client who receives any sort of notice, whether that's a pay or vacate, comply or vacate, get them in contact with the Housing Justice Project. And I do have a link for the King County HJP at the end of this PowerPoint. For anywhere else in the state, I would highly recommend that the young person contact the Clear line. Again, I have that information at the end of the PowerPoint as well.
Laurel, we do have a couple of questions actually that just came in, if I can.
Yeah, absolutely.
So one is from Laura at Clark. Are legal services across the state, is it different in all areas?
Yes, it is. I wish that I could say that it was not, but so the major legal aid provider, the biggest legal aid provider in Washington is Northwest Justice Project. And I believe that they have 17 offices around the state. But the offices may work on different types of issues. They do run a legal advice line called the Clear Hotline. That the purpose of that is to either get the caller connected to appropriate legal services in their community, or to provide limited advice and counseling over the phone to help them navigate the issue. Our office is based in King County. The part of my program that I run is the King County program. I'm really familiar with the services that are here, but there are local services that are done by county or municipality that may be available that I'm not aware of. So it's the Clear Hotline is much more well versed in getting folks connected to local resources from wherever the client may be calling.
One more, are there any protections for survivors and victims of domestic violence if they get an eviction notice due to DV?
Yes. So DV is definitely a mitigating factor when it comes to any complications around lease agreements. So there are protections in place specifically around, well, we talked about changing locks, but that's a very small one. For folks who are experiencing domestic violence or who are exiting a violent relationship, there are protections that allow survivors to terminate a lease agreement without penalty. They can even provide notice of that exit after the fact. There are specific timeframes and the types of documentation, whether that's a copy of a court order or documentation by a law enforcement officer about a domestic violence report or incident, that are required to go to the landlord within a set period of time of when the tenant leaves housing. So it's definitely worth getting them some support around how to navigate that with the landlord. In my experience, when survivors are having to go back and retroactively deal with that type of situation with landlords, I have found folks to be pretty accommodating and wanting to make the situation work. But there are specific statutory requirements that the tenant has to comply with. Are we all set?
Yes, we're all set. We have about 5 minutes left scheduled, but I think you can go over a few minutes and it won't kick us off.
Okay, sounds good. Okay, so when leaving I'm not going to talk anymore about eviction because I think we've sort of covered my notes on there so far. One of the most important things to know about leaving an apartment is how much notice you have to provide the landlord. Generally speaking, if the tenant has signed a term lease agreement, so again, this is for a set period of time, whether that's 6 months or 12 months or 18 months or whatever it is. Generally speaking, if the tenant wants to leave at the end of that lease agreement, they do not have to provide notice. There's no statutory requirement that they provide notice. And generally speaking, a term lease agreement is legally understood to be over at the end of that lease agreement unless the parties agree to extend it, or it gets converted to a month-to-month tenancy, which we'll talk about right now. That said, if there is a clause in a lease agreement that says that the tenant should or shall provide notice of their intent to leave before the expiration of the lease, it is usually easier to just provide that notice than it is going to be to try and fight with the landlord about it afterwards. You don't have to provide the notice, but it might be easier to just do it if your lease requires you to do it. So worth knowing if there is any requirement in the lease agreement upfront. For month-to-month agreements, your term lease agreement can convert to a month-to-month if the tenant does what we call holds over at the end. So if I'm going to sign a lease agreement for 12 months and it's from January to December, and on January 1st, I pay January rent to my landlord, so it's my 13th month of my 12-month lease agreement. As long as my landlord accepts that payment, my lease has been legally converted from a term lease agreement to a month-to-month lease agreement. So I no longer have all that protection that I did under the terms of my original lease agreement. Those terms are generally considered to be the same until the landlord changes them, but the landlord can now change them. But with month-to-month agreements, there is a notice requirement, and tenants have to provide written notice of their intent to leave 20 days before the end of the lease term. So if I decide that I want to move out April 30th and I've paid April rent, so I paid rent on April 1st, I want to move on the 30th, I have to provide written notice to the landlord by April 10th. If I provide notice on April 11th or 12th or the 24th or basically any time after the 10th, my notice doesn't really apply until the following rental period, which means that I'm going to be legally responsible for paying both April rent and May rent because it has to be 20 days before the end of the rental period. Let's see. Whether you're required to provide advance notice or not, or whether you do provide advance notice or not, you do want to make sure that your landlord has a good forwarding or mailing address for you, because that is where they're going to send the return of your security deposit or any charges, communication about any charges of damages or repairs that they're alleging that you owe at the end. If you don't provide a forwarding address, the landlords are required to use the last known address, which will always be the rental property that you're leaving. So that just means that it gets sent to the place that you just moved out of, and unless, the post office might forward it if you've changed your address with the post office, but best practice is to make sure your landlord has a good forwarding address. If you leave before the end of your term lease, you're responsible for paying the lesser of two amounts, either the total amount of rent that would have been owed for the remainder of your lease agreement, or however long it takes the amount of time that the property goes unrented. So landlords are legally required to mitigate their losses. They have to try to relet those units, even if their tenant breaks the lease. So whatever is less, if I leave at month 6 and it takes the landlord 3 months to rent my unit, I'm responsible for those 3 months of rent. If they rent it within 30 days, then I'm only responsible for 30 days. Landlords have 21 days to provide a full return of any security deposits, any refundable security deposits, or to provide a written accounting of what they're keeping and why. So if I pay $1,000 security deposit and when I move out, and the whole thing's refundable, and I move out and the landlord says that they have to do $250 worth of carpet cleaning, they have to provide the $750 and the accounting of the $250 that they're using for carpet cleaning to that written address that I provided to them within 21 days. If not, I'm automatically entitled to a full return of any refundable deposits. It does not mean that I'm not responsible for those damages. It just means that the landlord can't withhold the damages from my deposit.
Laurel, can you repeat that time frame again, that landlords have to send a notice?
21 days from the day you move out.
Okay, thank you.
Mm-hmm. you're not entitled, like tenants are not going to be entitled to the return of any non-refundable security deposits or fees that they paid up front. So again, wanting to make sure they're really clear about what they're paying at the outset is really important. We oftentimes will end up talking to folks who are like, I paid a $750 deposit and my landlord won't give it back to me, but then we go back and look at their lease agreement and the whole thing was non-refundable. So really wanting to make sure that you're clear about what you're paying at the outset will make it a lot easier to navigate this stuff when you're leaving. And again, this is also that time where the move-in checklist is going to be worth its weight in gold, because you're going to have all that documentation about exactly what the condition of the apartment was when you moved in. So if the landlord's alleging that you're responsible for replacing the carpet because there's a stain on it, but the stain was there when you moved in, then we can absolutely, challenge the landlord's, charges and get that remedied. Okay, I know we're kind of right at time. We didn't get to a hypothetical yet, but I want to make sure to answer any more questions.
I don't see any coming through right now.
I don't know, do folks want to stay and do the hypothetical, or is that just like asking for too much time at this point?
Someone said, yes, please.
Okay, I mean, I'm happy to do that if folks want to stay for a few more minutes.
Yeah, I see some folks have left, and that's okay. Yeah, I think that we can continue, and for folks that have left early or weren't able to make the webinar, they can catch that on the uploaded video later. Yeah, and I saw another person said yes, so I think that folks do want to hear that.
Okay.
Yeah.
Great. So I'm going to flip forward a few slides. So basically, these are sort of the questions that I want folks to have in mind. Can you identify at least 3 points where Maria could have benefited from earlier assistance and/or intervention by a service provider or attorney? What preventative measures or mitigating steps could be taken at each of these points? And at what points could Maria and/or her case manager contact an attorney? So those are just some questions to have in the back of your mind when we go through this scenario. And then if folks want to chime in with thoughts, that's totally great. I would love that participation, but I'm also happy to just go over it, whatever is easiest, depending on if people want to share. So here's our scenario. Maria had been living in an apartment with a roommate for the past year. When they moved in, they noticed that there were a couple of tiles missing in the bathroom and a stain on the living room carpet, but it wasn't very noticeable, so it didn't bother either of them. They both signed a 12-month lease, but ended up staying an extra couple of months after their lease ended. After that, they both decided to move to different apartments, so Maria called their landlord and told them that they wanted to move out at the end of the month. 2 weeks after she moved out, Maria received a letter and bill from the landlord stating that she owed $24.50, so $2,450, including an additional month's rent, replacement of the missing bathroom tiles, full carpet replacement, and replacing the closet door in her roommate's bedroom, which apparently had been broken when her roommate moved out. So there's a lot going on here. Which was kind of the idea, but we see this all the time because it's very often that there's not just one thing going on. So do folks want to chime in with some thoughts on, can you identify 3 points in time where Maria could have benefited from some earlier assistance or maybe some guidance from a case manager or an attorney?
So we had, Lauren said that they should have them on the checklist. They went to a month-by-month lease, so she stayed and it's now all on Maria.
Yeah, those are great. Yeah, wanting to make sure that those damages, like the things that were already damaged when they moved in, having them on the move-in checklist would have been very, very helpful, because then we could point to the move-in checklist at this point and say, look, those tiles were already missing. There was a stain on the living room carpet. So if that's the reason why the landlord's alleging that the carpet needs to be replaced, then that's not a fair charge, and it shouldn't be on Maria and her roommate to pay for that. Yes, and they also converted to a month-to-month lease, which means that they had a 20-day notice requirement. So in Maria's case, not only did she not provide the 20 days notice, but she also provided the notice verbally. So best case, she would have either sent a letter or an email to notify the landlord that they were wanting to move out. But because the notice wasn't provided 20 days ahead of time, well, it doesn't say that it wasn't provided 20 days ahead of time, but let's just assume that it wasn't. That would have been why the landlord had the right to charge them for the next month's rent, because they hadn't provided a proper amount of notice. Any other?
Also, from Laura, the closet door should have been brought up when they noticed there was an issue.
Yes, absolutely. Should have brought it up right away. And this is one of those, going back to our earlier conversation about joint and several liability. So even though the closet door was in her roommate's bedroom, the landlord can still hold Maria financially responsible for the repair to the closet door. The landlord doesn't really care who pays for it. Like, it can be Maria, it can be her roommate. He or she, the landlord can go after both of them for the full cost of the repair. He's not entitled to it twice, but is entitled to get the full amount from one or both of them. And then they can figure out how that cost should be split between them, either by agreement, or if Maria pays it, she could take her roommate to small claims court for compensation for having to pay for a repair that that she doesn't believe was her responsibility.
Question from Renee is, but also because Maria notified by phone rather than in writing.
Can you repeat that?
The question from Renee is, but also because Maria notified by phone rather than in writing.
Yeah, so notice does need to be in writing. Sometimes landlords will be accommodating and accept verbal notice, especially depending on the relationship that tenants have with their landlord. Like if it's, if they're renting from a private landlord and they have a good relationship and, they have lived there for over a year at this point. So the landlord may have decided to accept the verbal notice, but the landlord was not required to do so. So even if, let's say, the 20 days, they had provided 20 days notice, but it was still verbal, that would have been a reason why the landlord could have charged them for the next month's rent. Because once landlords know that someone has moved out, they do have to accept that as formal notice that the person has left. So just by virtue of them being gone, that's notice. But it didn't necessarily relieve them of their responsibility to pay for the rent for that notice period. So there's two different ways why the landlord could have alleged that additional month's rent, either improper timing of the notice or improper format of the notice. One thing would have been to know what sort of cleaning requirements. I know we didn't really talk about this, but the landlord may have required that they pay a cleaning fee, and whether or not that's being charged in there, we're not sure. Let's see. We talked about the move-in checklist. The fact that it converted to month, joint and several liability. Yeah, so those are, I honestly have seen every single one of these specific things come up for clients. Also, as someone who has a very long rental history myself, like I've also experienced these. These are really, really common scenarios that folks have when they're leaving a rental unit. So really helping young people to understand what their rights and responsibilities are, be really diligent about understanding their budget, understanding the terms of their lease agreement, understanding what they're going to be financially responsible for when they move out, and how to go about, not only signing a lease and understanding the agreements up front, but also what to do when something goes wrong. This would be, Maria's case would be something where she would absolutely benefit from having an attorney, because an attorney could help her dispute this with the landlord, challenge whether or not the repair costs were valid, whether or not the carpet replacement was valid, help Maria understand what her options were in terms of paying for the replacement of her roommate's closet door, those sorts of things. So if you're ever working with a young person who's dealing with this sort of situation, an excellent time to get them connected to legal services. So on that note, I'm going to kind of skip this.
Laurel, there's a quick question.
Yes.
Where are the 7 locations for the drop-in legal clinics?
Oh, that's a great question. So our legal clinics are, we have 2 every month at the Accelerator YMCA at the 2100 building in South Seattle. We have 1 at New Horizons Ministries in Belltown, 1 at the Landing at Friends of Youth over in Redmond. We have 1 in Everett at Cocoon House U-Turn Center. We have 1 in Tacoma at the Reach Center, and then 1 in Tacoma at the Hype Center, which is run by Comprehensive Life Resources. All of that information I am happy to share with folks. So Donna, I don't know, is there a good way for me to disseminate that information to?
If you share that to me, I can actually include that in the description on the YouTube channel.
Perfect, yeah. So I'll make sure that that gets included so that folks know how to access our drop-in legal clinics. The other thing is that my contact information is the last slide of this PowerPoint, and you folks do not have to come to clinic to access services. We are always happy to connect with young people, whether by phone or email as well. So if it's easier for someone to send an email or give me a call at their convenience, that's like, we try to be as low barrier as possible. I do want to just sort of skip to this resources slide. This specifically talks about other resources besides just my program that can provide assistance for folks who are dealing with landlord-tenant issues in Washington. The Housing Justice Project, again, that link specifically is to the HJP here in King County, but I know for a fact that both Snohomish and Pierce counties have HJPs of their own. There may be other counties that run them through their county court that I'm just not aware of. The CLEAR hotline is the hotline that's run by the Northwest Justice Project, and they are very well versed in what statewide resources look like on a county by county basis. So if you're working with someone who is, again, outside the I-5 corridor, where I'm most familiar with resources, CLEAR is a great way to either get the young person connected to a Northwest Justice Project attorney, give them some limited advice and counseling, or get them connected to other resources in their community. The Tenants Union of Washington State is, I think, a phenomenal resource. It is not run by attorneys, but they do have tenant counselors available. So if you have a participant or client that you're working with who has some questions or concerns, whether or not something's actually arisen to what we would call a legal issue, but they just want to understand what their rights are or what their responsibilities are, the Tenants Union is a really good place to start. And then Washington Law Help is a bank of self-help resources that I think are really well done. They deal with all sorts of legal issues, not just landlord-tenant law, but they have really every type of legal issue, civil legal issue you can imagine. They have resources available. It's a great place to point young people if they just want to better understand their rights, responsibilities, and options. And then finally, here's my contact information. Even if you are outside our official service provision areas, or if you have questions or a young person that just wants some advice or counseling, I'm happy to be a resource. If we cannot help them with their legal issues specifically, I will work hard to get them connected to someone who can. So please don't hesitate to reach out or send folks my way if they have questions or concerns.
Thanks, Laurel. Just one quick thing as we're talking about resources, question came in about, do you know of any resources or tips on how to search for housing options, especially for someone who has no rental history or can't get a cosigner?
You know, I wish I had more knowledge on those types of resources. My program specifically just deals with like the legal side of things, so I'm not well versed on the current resources that are available. I know that a lot of the programs that we partner with, like the YMCA, Friends of Youth, the Reach Center, Cocoon House, have case managers that specifically work on housing issues who are really good at getting folks connected to either rental assistance programs or work on developing relationships with specific landlords or property management companies that are good about reducing barriers for new renters, or for our clients that come in with some of those barriers that we talked about, whether that's a past eviction or a juvenile record or credit or debt issues. So I think that there are lots of service providers around who are working on this much more intensely than I am. But if you are looking for that sort of resource for a young person within your program, feel free to reach out, and I'm happy to get you connected to folks that I might know who can help connect them to those resources.
Great, thanks, Laurel. My computer just died, so that's why you saw my screen go away, but I'm still here through the WPN account. And just wanted to say thank you so much for sharing your expertise with us this afternoon and answering questions about housing rights. I think that folks found this helpful, and I'm happy that we're able to upload this onto our YouTube channel. And for the folks that are still on, I just wanted to mention that we have a brief survey, just 7 questions. Hopefully it'll only take you a few minutes to answer, but we would love to get your feedback on the webinar so far, specifically this webinar, and ways that we can improve the webinars that we offer to the WPN members. So as soon as this webinar is closed down, you'll see a screen that pops up for you to take that survey. And then if you're not able to take it at this time, you'll receive a follow-up email tomorrow with the link to complete that survey. And then that link will also, or that email will also include a link to view this webinar on our YouTube channel. And then just wanted to say that we'll resume our webinar series in mid-January next year. So I hope that you're all able to join us, and thank you, and we'll see you next year. Thanks again, Laurel.
Thanks, Donna.
Thanks, everyone.